Good morning, everyone. As Kirshner has mentioned now, I'm Gert. I'm an IP specialist, specifically in relation to copyright and trademarks at the university's Technology Transfer Office in Novus. Now, before I jump into this presentation, I thought it would be best to give you a brief background on copyright. I think you might find this informative and hopefully interesting as well. So first and foremost, what is copyright? So copyright is a form of intellectual property, and intellectual property can be described as being the products of human intellect. So anything that you can possibly think of, any creation, any invention that could potentially be legally protected, and then you would have rights to those specific creations or inventions, and those rights would then be regarded as being intellectual property rights, including copyright. Other forms of intellectual property that you might be aware of include trademarks, patents, as well as design law. So under our South African copyright regime, our copyright system is derived from our Copyright Act. Now, our Copyright Act provides a legal system through which you would be able to get certain ownership rights in relation to copyright, but also certain usage rights. I will get into that in a moment. Most of you might be familiar with our Copyright Amendment Bill. Our Copyright Amendment Bill has been in the making for about 12 years now, approximately. And this bill has now been presented to the Constitutional Court. So our president has again referred this bill to the Constitutional Court to test the constitutionality of the Copyright Amendment Bill. There's certain aspects in the Copyright Amendment Bill that would drastically change our copyright system at the moment, specifically in relation to fair dealing exceptions. I will get to fair dealing exceptions in a while as well. Under our current Copyright Act, there are 3 requirements for a specific work to be eligible for copyright protection. Firstly, there are 9 categories or 9 types of work put forward in our Copyright Act, and all types of work that could potentially be eligible for copyright protection must be able to fit into one of these 9 categories, 9 classes of works. So some of these classes or categories that you might be familiar with include literary, musical work, artistic work, film recordings, and sound recordings. A second requirement, also put forward by our Copyright Act, requires that the work must be original. Important to note here, for work to be original, you won't necessarily look at the novelty or the quality of a level of this specific work, but rather originality is tested according to the skill and labor that the author has exerted or exercised to create that specific work. So you would be, even for a simple line drawing or a line sketch, something that is so simple as that, would also be eligible for copyright because there was a certain skill or labor that was needed in order to create that specific work. And then a third requirement, a work must be reduced to a material form in order for it to be eligible for copyright protection. So there must be some sort of physical embodiment or physical manifestation of that specific work for it to be eligible for copyright protection. Important to note here, it is important to draw a distinction between ideas and expressions. Accordingly, under copyright protection, you would not be able to protect your ideas. Your ideas needs to be transformed to a material form for it to be eligible for copyright protection. Now, some examples of copyrighted works that you might be familiar with and that you might deal with while writing up your thesis or your dissertations typically include textbooks, published articles, musical compositions, sound recordings, as I've mentioned, and then as well film recordings and photos. So all of these types of works are recognized in our Copyright Act and would therefore be eligible for copyright protection. Now, getting into the nitty-gritty technical part, and this can be a bit confusing, so I'll try to simplify this as much as I possibly can. So our Copyright Act provides for a distinction between authorship and ownership. Important to note here, an author would always be the person that created the work or the person that was responsible for reducing that specific work to a material form. Also, very important to note, it is not possible to change who would be regarded as being the author of a specific work. So authorship is always fixed. You would always be regarded as being the author of a specific type of work. Authorship cannot be transferred, it cannot be assigned. Then getting to ownership of copyright. So the owner would typically, in most cases, be the author of a specific work, but there are also certain exceptions. Our Copyright Act provides for certain exceptions whereby the author or the original creator of a specific work would not be the copyright owner of that specific work. Under our legislation, it is also possible to change or to alter who would be the owner of a copyright work. And this brings me to our institutional point of departure, or the position that we follow within the university. All of you that are on this call has a staff employment agreement or either a student contract. And according to our employment contracts and our student contracts, we need to abide by the university's intellectual property policy. And as you probably would know by now, according to our intellectual property policy, the ownership of copyright for works created by staff members during the course and scope of their employment under the university or by students created during the course and scope of their studies would be, or the university would be the owner of that copyright. This brings me again back to the point that I've highlighted earlier regarding this difference between authorship and ownership. You would always be regarded as being the author of your thesis or your dissertation. But, however, under our staff employment and student contracts, as well as our IP policy, the university would be the copyright owner of that specific work. Getting to infringement. So as the copyright owner would be allowed certain restricted acts or exclusive rights that only the copyright owner are allowed to perform in relation to their work. So should another person, without the express permission or authorization from the copyright owner, perform any of these restricted acts in relation to a substantial part of the original work or of the copyright owner's work, they could be liable for copyright infringement. So some of the most important restricted acts, and again, remember, restricted acts may only be performed by the copyright owner. Some of the most important restricted acts that are recognized within our copyright legislation includes reproduction and adaptation. So reproduction would typically be the mere copying of a work to create, or merely copying a work. And then adaptation of an original work would typically be that the work is transformed or altered or modified in some sort of way to create a new derivative work. So it is extremely important to take note of these two restricted acts. Again, only the copyright owner or a person with the necessary permission from the copyright owner would be allowed to perform these restricted acts in relation to the copyright owner's work. Now, just briefly, I'm not going to go into much detail of on this. Our courts have laid down a two-step test for determining copyright infringement. So firstly, a work must be reproduced or adapted from the original work, and that must be a substantial part that must be reproduced or adapted. Important to note here, substantiality is in this case not specifically referring to the quantity or the amount that you have reproduced or adapted, but rather looking at the quality of the original work that has been reproduced and adapted. And then a second step that also must be complied with for proving infringement is that there must be a causal connection between the original work and the newly created work. So there must be a clear indication that the original work was used as a source to create this new work. Important to note here, and I will get back to this point again at a later stage. When it comes to infringement, you need to be aware of the university's intellectual property and then also third parties' intellectual property. So I will get to, or I will show you examples in a moment of both the university's intellectual property and third parties' intellectual property. And you need to steer clear when using SU's content and when using a first party's content to ensure that you are not infringing on their content. Just briefly, plagiarism, there's a distinct difference between copyright infringement and plagiarism. Important to note here, however, there might in some cases be an overlap between plagiarism and copyright infringement. So basically, plagiarism is the misappropriation of another person's ideas or words, and these words can be spoken words as well as written words without properly acknowledging or without attributing the original source of this work. So this is the main difference between infringement and plagiarism. Infringement specifically relates to material forms only. So there must be reproduction or adaptation to form another material form of the work. Plagiarism could relate to spoken words as well. Now, plagiarism is not necessarily legal implications relating to plagiarism, but there might be certain moral or ethical implications. The problem with plagiarism is that the plagiarist falsely claims that they are the original author of the work. So this then affects the original author's reputation, and this might lead to fraud. So there's certain moral or ethical implications that relate to plagiarism. And as I've mentioned, in some cases, there might be an overlap between infringement and plagiarism. So if you were to reproduce or adapt a substantial part of an original work, and there's a clear causal connection, that might result in infringement. But to add to that, and to also then potentially be liable for plagiarism, if you are also not acknowledging the original source and claiming it as your own work, that might then also lead over and above to infringement, to plagiarism as well. So you need, while you are doing research, while you are writing up your thesis or your dissertation, you need to make sure that you steer clear from infringement. So I will go through certain exceptions now. So you always need to ensure that the research that you are doing, or while you are writing your thesis or your dissertation, that your dealings fall within these exceptions. So firstly, so there are certain exceptions referred to in our copyright legislation, specifically on fair dealing, as well as when certain work will fall into the public domain. Under fair dealing and public domain work, you are free to use and exploit that work fully without having to seek permission from the original copyright owner. And then in certain instances, you would need to check the licensing terms and conditions that are attached to a specific piece of work. And you need to ensure that you comply with those licensing terms and conditions to prevent that you are infringing the original work. And then, and this would be the case in most instances, you would need to reach out to the copyright owner, or firstly determine who the copyright owner of a specific work is, reach out to them and seek permission to use their content. Now, getting, as I've mentioned earlier, fair dealing, this is an exception provided for in our copyright legislation, and there are free fair dealing exceptions referred to in our Copyright Act. And the most important one for purposes of this discussion today is this exception that relates to research or private study or personal or private use. So according to this exception, you would be allowed to make a single copy of a reasonable portion of the original work, and you would be allowed to use that specific copy for research purposes only. Important to note here, you would not be, under this exception, be allowed to include that specific copy or parts of that specific copy in the final work that you submit as part of your thesis or your dissertation. And then, as I've mentioned earlier now, certain works would also be available in the public domain. So copyright is of a limited duration of 50 years after the death of the author. Important to note here, this relates to the death of the author. So you need to determine who the original author is and not the copyright owner. And after this period, the work will fall into the public domain, and you are free to use the work without having to seek permission from the original copyright owner to utilize that specific work. And then in other cases, you would need to check the licensing terms and conditions that are attached to a certain piece of work, and you need to ensure that you comply with those licensing terms and conditions. Firstly, you would need, and you will see this in most cases, you would need to locate the licensing terms and conditions that are available and that relate to a specific piece of work. An example you can see here on the slide, should you wish to use, for instance, an image from the website Upsplash. In this case, you will see the licensing terms and conditions indicate here that photos from this website may be downloaded and used for free. It can be used for commercial and non-commercial purposes. and no permission is required from the copyright owner, but they do encourage that you acknowledge your source in this instance. You will also see here that there are two terms and conditions indicating what you are not permitted to do in relation to this work. So a work cannot be sold which you have downloaded without a significant modification to that specific work. And you can also not use the photos that you've downloaded from Upsplash to replicate this and to then make a competing or create a competing service to Upsplash. Another example, this is from StockSnap. So if you intend to use any images from StockSnap, you will see here, in this case, that their images are governed by a Creative Commons license. So under this Creative Commons license, you will see here, I hope you can see it, it indicates that you may copy, modify, distribute, and perform work under this specific license. It can be used for commercial and non-commercial purposes, and you do not have to ask permission from the copyright owner to use their work. Linking to my previous slide, specifically on Creative Commons licenses, you would see, and this is specifically for the use of images, certain, yes, not even specifically images, other pieces of work, textbooks specifically, can also be licensed under Creative Commons licenses. There are 6 different Creative Commons licenses, and these licenses would usually give an indication as to whether you may reproduce or adapt a specific piece of work, whether it can be used for commercial or non-commercial purposes, whether you would need to seek permission from the original copyright owner to use the work, as well as whether an acknowledgement is required from the copyright owner under this specific Creative Commons license. I urge you to visit the Creative Commons website. You will see on their website they give an indication of different types of work that have recently become available under Creative Commons licenses. So please use this as a tool, as a database, to see which works you can utilize under a Creative Commons license. So this would be the case in most instances where you would need to reach out to the copyright owner and seek their permission to use and include their work in your thesis or your dissertation, or to use it for research purposes. Now, firstly, you would need to find out who the copyright owner of a specific work is. And this information you will typically find under a copyright notice or the terms of use. It's usually easy to find this information specifically on websites. There would be a clear indication of where the copyright notice or the terms of use are located, and you would then be able to determine who the copyright owner is, and from them you would then need to seek permission. An example that I'm showing you here on the slide is, for instance, if you were to use a figure, a chart, a table from a Springer Nature journal, you will find on Springer Nature's website, they have a copyright clearance application form. You can fill in the necessary details, and they would usually get back to you and give an indication as to whether your request was granted. And they may then also prescribe certain requirements or restrictions that you need to comply with for using their content. In a similar vein, if you were to use content from an Elsevier journal, if you were to use any figures, charts, or tables from their journals. You would also see on their website that they have a copyright clearance application form. Again, you can fill in the necessary or the requested information, and they will get back to you as to whether your request was granted and whether there are any additional requirements or restrictions that you need to adhere to for using their content. Now, as I've mentioned earlier, you need to draw a clear distinction between using the university's intellectual property or using the university's copyrighted content and using a third-party content. So when you are using the university's IP or copyrighted content, you also need to locate or find our copyright notices and our terms of use, which I am going to give to you now here. And this is also what I've mentioned earlier. This information is indicated in the university's IP policy. As I've mentioned earlier, any work created by staff and students during the course and scope of their studies or employment would vest in the university. So accordingly, to seek permission from the university, you would need to follow the same channels as for third parties. Reach out to the university and seek permission for using their copyrighted content. An example of this, should you want to use a staff member's course material in your thesis or your dissertation or for research purposes, you would need to request permission from the university. In note here, staff employed, accordingly, the university is the copyright owner of the course content that they have created, and the university would therefore need to give permission for using their content. Another example is, should you want to publish from your thesis or your dissertation, you would also need to get in contact with the university to get permission to use content from your thesis or your dissertation. Important again to note here, the university is the copyright owner of your thesis or your dissertation. So should you want to use any content from your thesis or your dissertation, you would need to seek permission from the university. So typically, you can contact our office. Our office would be able to grant permission for using the university's copyrighted content for purposes of publishing from your thesis or your dissertation. And we will then liaise with your faculty heads and also get their permission. So your faculty heads in this instance would either be your supervisor. If your supervisor is perhaps external or no longer employed at the university, we will need to reach out to your HOD or your dean for their input and to then also get their permission for you to pursue this publication. Another important point just to take note of for purposes of publication from your thesis or your dissertation, anything that you negotiate with a publisher, any publishing agreements that you would conclude, any negotiations, this is done in your own name and for your own account. So you are more than welcome to negotiate with a publisher that they would be the copyright owner of your publication. And then we can just prescribe certain requirements or restrictions, and that would typically be only an acknowledgement indicating that the university is and will remain the copyright owner of the underlying work for your publication. The university, however, is not the copyright owner of your publication. So you are welcome to negotiate on further terms regarding this with your potential publisher. Now, just a few last pointers, that's important to take note of. When you are using copyrighted content, either from the university or from a third party, try to paraphrase as much as possible, and also try to use an insubstantial part from the original work. Using an insubstantial part will make sure that you fall within the fair dealing exception, and this will then prevent you from any potential infringement at a later stage. Also important to note here, make sure that you always acknowledge the sources that you are referring to. This would typically be a requirement that the copyright owner, when seeking permission, prescribes, so make sure that you always appropriately acknowledge it according to their requirements or their restrictions. When you are submitting a request to a copyright owner to ask permission for using their copyrighted content, and you do not receive any feedback, the best port in this case would rather be to remove that specific source and try to find an alternative source that can perhaps provide you with the same information. However, if you are dead set on using that specific copyrighted content, please make sure that you keep your email correspondence, your requests, any feedback or any correspondence with the copyright owner to ensure that you've at least taken reasonable steps in order to prevent or in order to obtain permission, rather. If there's any backlash at a later stage, you can then at least prove that you've taken steps to obtain permission, and then we can use this possibly as a mitigating factor against potential infringement. And then just a last note, and this is probably the most important. It is fully within the copyright owner's discretion to prescribe additional requirements or restrictions that they might attach to the use of the work. Remember, it's the copyright owner's property, it's their assets. So they are fully within their discretion to give an indication as to how you would be allowed to use their work. So make sure that you comply with any additional requirements or restrictions that the copyright owner prescribe for the use of their work. Then just on a last note, and I'm definitely not going to go into much detail on AI and copyright, but I would be remiss to not briefly mention this as well. So obviously, you know, we have now seen in the recent years an uprise of AI chatbots, AI generators, and these AI machines, AI tools typically reproduce and adapt and are trained on copyrighted content. And this is usually done without the permission of the copyright owners. So this creates the opportunity for infringement. We have now seen a slew of legal actions being taken against several AI machines in the recent months. You will see here on this slide, Thomson Reuters recently won a case against Ross Intelligence. So Ross Intelligence is an AI legal research platform, and they've used Thomson Reuters Westlaw as Westlaw platform's content, obviously without permission, and they recently won this court battle against Ross Intelligence. Other examples that you will also see here is that there were also a few famous authors that recently instituted legal action against Meta. Apparently Meta's AI tool Llama AI used some of their book publications to train their machines or the AI machine on, again, without permission from those authors. And then lastly, and this has been going on since last year, is the New York Times also is currently embroiled in a legal battle with OpenAI, specifically as or due to the fact that these or OpenAI are currently also being or was at that stage being trained on the articles from the New York Times. So we will need to watch the space and see how this turns out. But I'm assuming that we can definitely see more of these kinds of lawsuits being pursued within the next couple of years. So when you are using AI, please be responsible when using this to avoid any sort of infringement, and do not make sure that you also do not follow or need to follow the path of any of these cases. Use AI specifically for research purposes and for private study only. If you are using it for research and private studies only, you can fall within your fair dealing exceptions. So you are more than welcome, again, to use AI for research or private study purposes only. This would be regarded as being fair use under our copyright law. And this would then also avoid potential infringement. Do not merely copy and paste or slavically copy content that is AI generated in the final versions of your thesis or dissertation. So stay clear of this and avoid infringement. And that is it from my side. If you have any questions at this stage, you are more than welcome to ask them now. Otherwise, send me an email. You are also more than welcome to do that. Thanks, everyone. Any questions? Any questions? Just not seeing any questions in the chat. Okay, I think if you do not want to speak up now, like I said, please send me an email. More than welcome to. Kirchner, I think we can close the presentation then. Okay, I don't think there's anybody left. Okay, thank you, everyone. I appreciate your time, and yeah, I will hear from you again. Thanks. All right, bye.